Copyright strikes? You're gonna censor the man with copyright strikes? I bet they didn't realize that they can lose their copyright if they abuse it. I bet they didn't know that, and I bet they figure that out pretty quick. Hello everyone, I'm Leonard French, your favorite copyright attorney, and today I thought would be a great opportunity to talk about the Wargaming versus Surfosh incident, where one of the streamers that Wargaming had as a community contributor made some critical comments, some very colorful critical comments about a new tank that Wargaming released for its free-to-play gaming platform, World of Tanks, and Surfosh was promptly removed from his status as a community contributor, but not before they also made him take his video down, threatening copyright strikes. It all started when Wargaming released its latest premium tank, the Chrysler GF, in anticipation of its annual Grand Finals tournament. Surfosh, who is a regular streamer and commonly reviews these things, had some choice words to say.
Wargaming, their terrible way of making these premium tanks lately, and this premium tank in particular.
Wargaming representatives then contacted Surfosh and asked him to remove his video after explaining that they were removing him from the community contributor program for his lack of professionalism, something they had gone to bat for him before, but no longer. Now, a copyright strike is a serious threat to anyone's YouTube channel, because more than one can seriously inhibit your ability to earn money with your content. And it's basically unnecessary in this scenario because they already removed him from the community contributor program. My first inkling was that something else was going on here, and the most obvious thing was that they just don't want a prominent member of the community ragging on their premium tank for which they want to make money, and they aren't going to make money if nobody buys it because they're listening to people like Surfosh and Circumflexes and others who say the tank is overpowered. Now, on the other hand, doesn't that mean that I should go out and buy the tank if it's overpowered? Anyway, after Surfosh took his video down, he put another one up explaining that he had been forced to take his video down and that he had been removed as a community contributor, and that pretty much triggered the entire community to rag on Wargaming for misusing their copyright. Wargaming finally issued several apologies, and the matter appears to be completely finished as far as any actual controversy between Wargaming and Surfosh is concerned. But you would not be watching this video if you didn't want to hear about the further implications had Wargaming decided to pursue Surfosh into some kind of court. And it turns out that there is actually an American court case on exactly this kind of issue, and there is international legal recognition for some kind of consequence for abusing your copyright. So, without further ado, I present to you the case of Lasercomb v. Reynolds, better known as Lasercomb v. Holiday Steel, a case where the Fourth Circuit affirmed an actual defense of copyright misuse. Holiday Steel and Lasercomb were competitors in the manufacture of steel dies used to cut and score cardboard for folding into boxes. Lasercomb developed a software program, which is the subject of the dispute. Using this program, a designer creates a template for a cardboard box cutout. In 1983, before Lasercomb was ready to market its cardboard box program generally, it licensed 4 pre-release copies to Holiday Steel. Holiday Steel circumvented the protective devices in the software and made 3 unauthorized copies, which it used on its computer system. It then created its own software program, which was almost entirely a direct copy, and marketed it as its own CAD/CAM die-making software. There is no question that the defendants engaged in unauthorized copying, and the purposefulness of their unlawful action is manifest from their deceptive practices. They do not dispute that they copied the software, but they contend that the plaintiff is barred from recovery for infringement by its concomitant culpability, its simultaneous bad actions. They assert that, assuming Lasercomb had perfected a copyright, it impermissibly abused it. This assertion of the misuse of copyright defense is based on language in Lasercomb's standard licensing agreement restricting licensees from creating any of their own die-making software. A successful defense of misuse of copyright bars a culpable plaintiff from prevailing on an action for infringement of the misused copyright. Here, appellants claim Lasercomb has misused its copyright by including in its standard licensing agreement clauses which prevent the licensee from participating in any manner in the creation of computer-assisted die-making software. The offending paragraph reads, "Licensee agrees, during the term of this agreement, that it will not permit or suffer its directors, officers, employees, etc. to write, develop, produce, or sell computer-assisted die-making software." We are persuaded, however, that a misuse of copyright defense is inherent in the law of copyright just as a misuse of patent defense is inherent in patent law. Although there is little case law on the subject, courts from time to time have intimated that the similarity of rationales underlying the law of patents and the law of copyrights argues for a defense to an infringement of copyright based on misuse of copyright. The origins of patent and copyright law in England, the treatment of those two aspects of intellectual property by the framers of our Constitution, and the later statutory and judicial development of patent and copyright law in this country persuade us that parallel public policies underlie the protection of both types of intellectual property rights. We think these parallel policies call for application of the misuse defense to copyright as well as patent law. Because of the lack of precedent in the copyright misuse area, some historical perspective is necessary. During the 16th century, it became common for the English crown to grant letters patent, which gave individuals exclusive rights to produce, import, and/or sell given items within the kingdom. These monopolies were granted for such commonplace items as salt, vinegar, and calfskins, to name a few. The practice of granting monopolies led to widespread abuses, such as shortages and inflated prices for items that would otherwise be easily and cheaply available. Consequently, Parliament passed the Statute of Monopolies, prohibiting the creation of monopolies by the Crown. An exception was made, however, to permit a patent to be granted for a period of 14 years to the creator of a new invention. The rationale for allowing patents for new inventions was and is to encourage their creation for the benefit of society. The monopolies granted by the Crown had been odious because they had restrained trade in articles that had previously been part of the public domain. An invention, however, does not withdraw anything from the public domain, rather it introduces something new. To encourage and reward inventors for increasing the inventory of useful objects, the government grants them for a limited time the right to exclude others from making and selling their inventions. The development of copyright law in England likewise grew out of a differentiation by Parliament between a monopoly that restricts publication of works and a limited copyright that encourages the efforts of authors. In 16th century England, the Crown granted to the Stationers' Company the exclusive right to publish and print all published works, apparently to enable censorship of Protestant materials. In the early 1700s, the Stationers' Company petitioned Parliament to recognize that these rights belonged to it in perpetuity. Instead, Parliament passed the Statute of Anne in 1709-1710, the first known copyright legislation. That statute gave authors the sole right of publication for up to 28 years. Thus, the English statutory treatment of copyright was similar to that of patent in that it granted the creator a monopoly for a limited time only. It is significant, we think, that the framers of our Constitution continued the English development of intellectual property law and considered in tandem those property rights protectable by copyrights and those protectable by patents. In giving Congress the power to create copyright and patent laws, the framers combined the two concepts in one clause, stating a unitary purpose to promote progress, Article 1, Section 8, Clause 8 of the U.S. Constitution. The Congress shall have power to promote the progress of science and the useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. The clause was adopted without debate, and material explaining the intention of the framers is limited. However, a comment in the Federalist Papers indicates the public policy behind the grant of copyright and patent powers is essentially the same. The utility of this power will scarcely be questioned. The copyright of authors has been solemnly adjudged to be a right of common law. The right to useful inventions seems with equal reason to belong to the inventors. The public good fully coincides in both cases with the claims of individuals. Supreme Court comment has likewise equated the public policies of copyright and patent. The economic philosophy behind the clause empowering Congress to grant patents and copyrights is the conviction that encouragement of the individual effort by personal gain is the best way to advance public welfare through the talents of authors and inventors in science and useful arts. Sacrificial days devoted to such creative activities deserve rewards commensurate with the services rendered. The philosophy behind copyright, parallel to that discussed above for patent, is that the public benefits from the efforts of authors to introduce new ideas and knowledge into the public domain. To encourage such efforts, society grants authors exclusive rights in their works for a limited time. Although a patent misuse defense was recognized by the courts as early as 1917, most commentators point to Morton Salt as the foundational patent abuse case. In that case, the plaintiff Morton Salt brought suit on the basis that the defendant had infringed Morton's patent in a salt depositing machine. The salt tablets were not themselves a patented item, but Morton's patent license required that licensees use only salt tablets produced by Morton. Morton was thereby using its patent to restrain competition in the sale of an item which was not within the scope of the patent's privilege. The Supreme Court held that it would not aid Morton in protecting its patent when Morton was using that patent in a manner contrary to public policy. The court stated, "The grant to the inventor of the special privilege of a patent monopoly carries out a public policy adopted by the Constitution and laws of the United States to promote the progress of science and useful arts by securing for limited times to inventors the exclusive right to their new and useful inventions. But the public policy which includes inventions within the granted monopoly excludes from it all that is not embraced in the invention. It equally forbids the use of the patent to secure an exclusive right or limited monopoly not granted by the Patent Office, which is contrary to public policy to grant." Thus, the Supreme Court endorsed misuse of patent as an equitable defense to a suit for infringement of that patent. Since Morton Salt, the courts have recognized patent misuse as a valid defense and have applied it in a number of cases in which patent owners have attempted to use their patents for price fixing, tie-ins, territorial restrictions, and so forth. Although the patent misuse defense has been generally recognized since Morton Salt, it has been much less certain whether an analogous copyright misuse defense exists. This uncertainty persists because no United States Supreme Court decision has firmly established a copyright misuse defense in a manner analogous to the establishment of the patent misuse defense by Morton Salt. The few courts considering the issue have split on whether the defense should be recognized, and we have discovered only one case which actually has applied copyright misuse to bar an action for infringement. We are of the view, however, that since copyright and patent law serve parallel public interests, a misuse defense should apply to infringement actions brought to vindicate either right. Both patent law and copyright law seek to increase the store of human knowledge and arts by rewarding inventors and authors with the exclusive right to their works for a limited time. At the same time, the granted monopoly power does not extend to property not covered by the patent or copyright. Thus, we are persuaded that the rationale of Morton Salt in establishing the misuse defense applies to copyrights. In the passage from Morton Salt quoted above, the phraseology adapts easily to a copyright context. The grant to the author of the special privilege of a copyright carries out a public policy adopted by the Constitution to promote the progress of science and useful arts by securing for a limited time to authors the exclusive right to their original works. Having determined that misuse of copyright is a valid defense, analogous to the misuse of patent defense, our next task is to determine whether the defense should have been applied by the district court to bar Lasercomb's infringement action against the defendants in this case. We conclude that in any event, the maintenance of the present suit to restrain petitioner's manufacture or sale of the alleged infringing machines is contrary to public policy, and the district court rightly dismissed the complaint for want of equity. The question is not whether the copyright is being used in a manner violative of antitrust law, such as whether the licensing agreement is reasonable, but whether the copyright is being used in a manner violative of the public policy embodied in a grant of the copyright. Lasercomb undoubtedly has a right to protect against the copying of their code. Its standard licensing agreement goes much further and essentially attempts to suppress any attempt by the licensee to independently implement the idea which their software expresses. The agreement forbids the licensee to develop or assist in developing any kind of computer-assisted die-making software. Lasercomb is attempting to use its copyright in a manner adverse to the public policy embodied in copyright law, and it has succeeded in doing so with at least one licensee. The language employed in the Lasercomb agreement is extremely broad. Each time Lasercomb sells its program to a company and obtains that company's agreement to the non-compete language, the company is required to forego utilization of the creative abilities of all of its officers, directors, employees in the area of CAD/CAM die-making software. Of yet greater concern, these creative abilities are withdrawn from the public. The period for which this anti-competitive restraint exists is 99 years, which could be longer than the life of the copyright itself. We previously have considered the effect of anti-competitive language in a licensing agreement in the context of patent misuse. The misuse arises from Lasercomb's attempt to use its copyright in a particular expression to control competition in an area outside of the copyright, i.e. the idea of computer-assisted die manufacture, regardless of whether such conduct amounts to an antitrust violation. In sum, we find that misuse of copyright is a valid defense, that Lasercomb's anti-competitive clauses in its standard licensing agreement constitute a misuse of copyright, and that the defense is available to the appellants even though they were not parties to the standard licensing agreement. Holding that Lasercomb should have been barred by the defense of copyright misuse from suing for infringement of its copyright, we reverse the lower court's injunction and its award of damages for copyright infringement. So isn't that something? Now, you may say to yourself, but, Leonard, I know that Surfash is in Latvia and Wargaming is in Cyprus, so doesn't that mean that none of this applies to them? Well, that's not entirely true, because all of that history that we talked about going back to England and all that, well, a lot of that's been occurring in other countries, in other treaties as well, and two of those treaties are the World Intellectual Property Organization and the Agreement on Trade-Related Aspects of Intellectual Property Rights, otherwise known as the TRIPS Agreement, of which the European Union is a member of both. And while it doesn't seem to get used very often, the doctrine of copyright abuse or misuse is alive and well in the legal research community in the EU, so I fully expect it's possible that that defense could be used in a case like Surfash's. The final question then becomes, did Wargaming overstep its copyrights? And I think they did, and I think that's why they backed off so quickly. Not only does it look bad for them to have used their copyrights in a way that's not related to copyright at all, but rather looks like a silencing of free speech, I think that was going to backfire for them to begin with. But then when you add in the fact that they can actually lose their ability to use and defend and enforce their copyrights if they overstep in too big of a way, they probably didn't have a whole lot to stand on in this case to begin with. So that's probably why they backed off so quickly. What do you think of the situation? Obviously, it's generated a lot of controversy over the last few days, so let me know in the comments below what you think, and I'll respond to as many of them as I can. I know a lot of you have been waiting patiently for an update in the H3H3 lawsuit, so have I. The judge has not issued any new anything since March 17th, and so we're just waiting to see what she has to say. It could be months, it could be weeks, it could be days, it could be in a minute. You know, let me go check. Thank you to all of my Patreon supporters, especially to the $50 plus supporters Joshua Meinsinger, John Cripps, Josh Bernard, Baxorn, and Weston Loney. Thank you as well to the $5 plus supporters that are scrolling on my LED panel to my left, and all of you are listed in the description of the video. Don't forget that you can join our live discussion on our Discord server, also in the description, and I think that's it. I'm looking forward to interacting with everyone in the comments, and I'll see you in my next video. I'm Leonard French, your favorite copyright attorney. Thank you so much for joining me, and I'll see you soon.